now I'd like to give each of you about a minute to do a summation or wrap up here on the key takeaways that you have. I'm going to start with Bill Bowden.
Thanks, Al. The key takeaways, in my view, for a claims purchaser are the diligence concerns that I mentioned before. If you're a purchaser, and even though it's going to add to the cost of the transaction, in order to make sure you're effectively getting what you pay for, you really need to diligence the documentation, if any, underlying the claim that you're about to buy. I can't emphasize that enough. The financial wherewithal of the seller is obviously critical too, because if you are, as I suspect any claims purchaser will, want to have some recourse against the seller in case things go sideways, make sure that your seller is solvent. That's all I have, Sal.
Thank you very much, Bill. Ken Epstein, some key takeaways?
Yeah, I think the the key takeaway is to get a funder involved early and often have a conversation with a funder about what's possible when you're a debtor in possession, a trust estate, or a creditors committee. Importantly, make sure a robust non-disclosure agreement is in place before you have any substantial communications with the funder. Make sure that the work product privilege is maintained, and look for opportunities to communicate about funding, and watch out for some of the ethical issues that exist, whether you're practicing or you're a plaintiff looking at using litigation funding. There are triplets and little traps that exist potentially in different states and jurisdictions related to jeopardy and maintenance. So make sure you're speaking to a funder that is well qualified to address those concerns, and a lawyer that is familiar with funding.